Good afternoon, everyone. I'm Derek Newton, Assistant Vice President here at the University of Toronto. I'm here today with Nina from the Centre for Research and Innovation Support and Dalia from the University of Toronto Entrepreneurship, who will be assisting with running the session today. On behalf of the University of Toronto Entrepreneurship, the Innovations and Partnerships Office, and the CRIS team, I would like to welcome you all to this session of the IP Matters series, which is focused on privacy, data governance, and trade secrets. We'd like to ensure that everyone has the opportunity to participate and hear what is being presented today. So should you need to turn on live captions, please go to your meeting controls under More Options and turn on or off live captions. And before we begin, we wish to acknowledge the land on which the University of Toronto operates. For thousands of years, it has been the traditional land of the Huron-Wendat, the Seneca, and the Mississaugas of the Credit. Today, this meeting is still home to many Indigenous people from across Turtle Island, and we are grateful to have the opportunity to work on this land. Now, a few housekeeping notes. Please mute your audio and turn off your video to ensure a smooth session and to accommodate those who do not have bandwidth. This session is being recorded. However, to encourage candor among the panelists and audience, the audience question and answer portion of the session will not be recorded. A link to the recorded portion will be sent out soon after the session. We're going to hear some great conversation from each panelist and a moderated panel discussion, and then there'll be an audience Q&A. And with that, it's my pleasure to introduce our monitor. Craig Atkin is a practicing lawyer and commercial litigator with an expertise in the treatment of trade secrets and confidential information as a commercial asset, outside of the perhaps better known understood context of IP rights, patents, and copyright. Craig also follows how the growth of privacy, regulatory regimes governing personal information affects these rights, as well as how information becoming publicly accessible may curtail privately held legal rights. Craig regularly represents clients at hearings, at trial, and in injunction orders and other enforcement matters. Craig, thank you for being here today. Over to you.
Well, thank you, Derek, and welcome everyone. I'd like to carry on. How a venture maintains confidential information, trade secrets, and governs data as a commercial asset is a critical element of intellectual property strategy. In addition to filing patents, which is not my area, I should mention, startups need to consider how to maintain privacy and to safeguard proprietary information and data as part of their technology and business strategy. I'm excited to discuss this topic with three fantastic panelists. Let me introduce them to you. First is Karima Bawa, who has been recognized as one of the most influential women in the IP industry by World IP Review. Is the co-author of the Intellectual Property Guide, IP Literacy and Strategy Basics for Supporting Innovation, and is a senior fellow at the Centre for International Governance Innovation. Karima is the inaugural chair of the board and of the newly created provincial entity IPON, the Intellectual Property Ontario, which has a mandate to work with innovators, businesses, and researchers at various stages of their IP journey. Karima also serves on the board of directors of the College of Patent Agents and Trademark Agents. Next up is Lawrence McPhee, who is the director of the intellectual property at Deep Genomics, a biotechnology company that focuses on AI-powered drug discovery and RNA therapeutics. Previously, he was a partner at Bereskin & Parr in Toronto, practicing in the life sciences. Prior to law school, at the University of Toronto, he completed his doctoral degree on the genetics on complex traits at Oxford. Lastly, but certainly not least, is Patricia Thane, who is the co-founder and CEO of Private AI, a Microsoft-backed startup who just raised their Series A, led by the BDC in November of 2022. She's also a computer science PhD candidate at the University of Toronto and a Vector Institute alumna. Her R&D work is focused on privacy-preserving natural language processing, with a focus on applied cryptography and re-identification risk. That latter is one of the things I was hoping she would touch on a little bit later. Patricia is a recipient of the NSERC Postgraduate Scholarship the RBC Graduate Fellowship, the Beatrix Trixie Worsley Graduate Scholarship in Computer Science, and the Ontario Graduate Scholarship. Right, so I'm very excited to hear what our three panelists have to say. But before that, I did want to touch on a couple key legal terms that are in the title, namely trade secrets firstly, and followed by privacy legislation. Just to give us some framework before we jump into it. First of all, the definition of a trade secret, or here in Canada in the Commonwealth, confidential information. Now, unlike patent, trademarks, or copyright, trade secrets or confidential information is not a statutory right. It's more of a common law catch-all category. So as a flexible common law concept, it protects a right to restrict the use or disclosure of non-generally or publicly available information. The legal standard is that it must be relatively inaccessible, to use the English term, or to use the American term, not readily ascertainable. Now, the wrong usually involves using or accessing the holder's information source, i.e. it is not like statutory IP, the patent, copyright, or trademark, where you're talking about an infringement within an area. Rather, the courts tend to talk in terms of a breach of confidence or the misappropriation of a trade secret. The legal wrong is often more in the nature of unfair competition, and also in practice, the concept of trade secrets or confidentiality tends to be intertwined, I would suggest, although this is more of an opinion, with contractual obligations such as employment agreements, NDAs, confidentiality clauses, and licensing, or that sort of thing. So it's wired quite differently. Now, the other half of this talk relates to privacy legislation and that exciting live low of regulatory compliance, everyone's most exciting. Anyway, okay, so the key linchpin here is that the legal regimes attached to personal information, or PI, if you're talking about it for any length of time at all. And you're often dealing with the Privacy Commissioner, both from the federal and provincial level. And this relates to some other concepts such as information custodians and de-identification. Now, I'm going to turn it over to our panelists very shortly, but I did want to briefly touch on some of the lingo. Federally, the statutes PIPEDA, or the Personal Information Protection and Electronic Documents Act. Provincially, we have parallel legislation here, very exciting for all the lawyers in the room. You have FIPA, the Freedom of Information and Protection of Privacy Act, and you often have health-specific regimes. And in Ontario, it's also confusingly pronounced FIPA, although it's the Personal Health Information Protection Act. So now that I've spouted enough legalese at everyone, I was going to pivot a little bit. And so each of our three speakers is from a very different background. I was hoping that you could tell us a little bit about what role intellectual property plays in your professional endeavors. My notes suggest that Karima should go first, but I'm happy for anybody to pick up the ball.
Happy to go first. So I came at intellectual property, having been general counsel for a company, BlackBerry, which I'm not sure some in the audience would be familiar with, but at the time was probably the company that was embroiled in the most litigation, got the title of litigation in motion around IP. And so, was heavily involved in that, heavily involved in developing a patent portfolio. Most recently, I have been appointed as the chair of IP Ontario, and that entails making sure that organizations within the Ontario actually have access to IP education services, mentorship, access to financial resources to help them commercialize, using IP to commercialize. So that's sort of my involvement with the IP regime.
Well, thank you very much, Karima. Lawrence, would you mind touching on a little bit about your background and what role intellectual property plays in your business endeavors?
Sure, yeah. So currently I'm director of IP at Deep Genomics, which is sort of a UT offshoot, which has had a fair amount of success the last couple of years. We're a biotechnology company, but sort of grounded in computer science. We were founded by a CS professor at U of T named Brendan Frey. And we were early on to the sort of AI-powered drug discovery. But we now see ourselves more as a drug discovery or a biotechnology company than simply a computer science or a software developer provider. So we have a range of technologies, which makes us quite interesting in the sense that we have maybe 30 or 40, CS specific researchers, as well as like wet labs and biotechnology as well. So it's quite a broad spectrum of technologies to protect. Of course, we only have one patent system. We have sort of one trademark system as well, or sort of one trade secret system. So we have to kind of select and choose how we protect that kind of diverse, innovation that we come up with, either on the computer side or over on the therapeutic side. So typically we'll use patents, of course, to protect anything which is public facing, like the therapeutics. But a lot of the work that we do does happen behind closed doors, outside of the view of the public. And in those cases, there's very valuable systems there, but they might be better off protected as a trade secret. So that's kind of my position. I've been involved in the IP community for a while, previously at Breskin and Parr, as you mentioned, Craig. And I've done lots of work for U of T in the past, and look forward to seeing more success stories kind of come up out of the entrepreneurships and ecosystem here in Toronto.
Right. Well, thank you, Lawrence. Now, I'm actually quite interested in your answer, Patricia. Unlike Karima and Lawrence, you have a computer science background. So rather than chattering about the law, you actually get your hands in and do it, is my sense. And I know private AI is often involved in anonymizing and de-identifying large data sets. And so with that setup, I was wondering if you could tell us a little bit about what role intellectual property plays in your professional endeavors, and maybe touching on what services private AI handles in the privacy regulatory compliance space. So.
Absolutely. In part, it's very similar to what Lawrence mentioned, public facing. That's when we consider whether or not we'll patent. Most of the time it's trade secrets. In some cases, I guess it's copyright when it comes to code. My role in that is assessing whether or not something is worthy of being patented, and with help of patent lawyers. As Craig said, I'm not a lawyer. I am a computer scientist by training. What we do with regards to helping folks with data governance and regulatory compliance is generally around the privacy space. So identifying and removing the personally identifiable information that you can find in unstructured data. So in 2019, no one was doing this properly for unstructured data, and we can now do this across 47 different languages, and do so for audio, text, images, documents, and so on. So yeah, happy to dive in more as we chat as to why that's interesting.
Yeah, well, I know I actually find that very interesting, and to actually apply some of the stuff I've been reading about for 10, 15 years. But until recently, it's been, well, how would you do that for large data sets? And I don't think there was a very good answer until relatively recently. And I don't personally have a good understanding of the answer, but as a lawyer, I'm glad that there is one. But so much of the audience is comprised of researchers and students in the university setting. I was hoping some of our panelists could pivot to what are some of the things that they should bear in mind when working with other researchers and with companies, more in a private or startup or entrepreneurial setting. What I'm trying to get at is moving from the university, everything is public information setting, to dealing with intellectual property and attempts to commercialize, control intangible assets.
I wouldn't say it's necessarily that dissimilar. If you're doing research in the academic domain, you might get worried about being swooped before somebody publishes the work that's similar to yours before you can publish. A lot of people are often thinking of the same ideas at the same time. So patents allow you to put your claim in the ground before anybody else can, or just publishing any information about the product that you're working on before anybody else can, allows you to put your stake in the ground as well.
So even within academia, you want to plant the flag, I take it. Sorry, Lawrence, I didn't mean to interrupt.
No, I was just going to jump in and agree. I think most great innovation, either pure scientifically or more commercially driven, starts with a bit of a secret, right? There's that discovery, there's that moment you're like, aha, this is not generally known, and I know this now, and that's a very exciting moment. And there is a tendency to want to share that immediately, but certainly, pump the brakes, check, maybe double check your math as well before you go to your supervisor or go to innovations that or seek a Series A funding or whatever it might be. But you certainly want to get a strategy in place as to either how you might publish something or how you're going to disseminate it or protect it. And so that's what's kind of unique about the IP space and what we're talking about today, is that there is kind of a commercial goal in mind here. And keeping things secret is very, very important. And sort of the process you go through is also key in terms of getting an investment, making sure you have all your ducks in a row, all those kinds of things. But it all kind of stems from that initial kind of secret or confidential discovery. And then you have a bit of a choose your own adventure to decide how to move it forward. But yeah, resist the urge to disclose. That's kind of the number one take-home message from anyone who's getting going on something like this, until you have a strong plan in place, until you've disclosed or discussed it confidentially with a patent agent, a lawyer, or some of the experts at U of T Innovations.
And I think the only thing I would add to that is that there should be some discussion around who owns what, right? In terms of you're working with and other researchers, or you're working with an organization that's, you know, outside of the university setting, understanding the university's policies around IP ownership, and really mapping out like publication, because for some researchers that becomes really important. And so making sure that I think all those contractual elements are nice and tidy right at the outset and complied with.
Yeah, that's a very interesting point, and I think it goes beyond the scope of what we're dealing with here today, Karima. But of course, if you hand it to a lawyer, then we can nicely draft up any confidentiality or joint ownership or proprietary rights. So that tends to be done by carefully negotiated contract happening, I think, but ideally before or certainly in parallel with the disclosures. So I think it's beyond what we're talking about today, but there are methods and mechanisms to do all of that. Okay, so. To turn to the next topic, many of the people in the audience are interested in having their own startups. Can you just explain how in practice a trade secret is different from a patent? And under what circumstances would a startup or business model rely on a trade secret or a data set or grouping of confidential business information rather than a patent?
Yeah, I'm happy to jump in here. As I say, most patentable inventions might start off as a trade secret. There is kind of an option to move something along, but the key thing is that if you have some information of value, it may or may not be patentable, but you can certainly keep it as a secret. Not all things do well as trade secrets, right? Anything, if it's some interesting design in a product that'll be eventually sold, well, that allows the public to discover maybe the interesting secret very quickly, and so you'll probably want to look at other forms of protection if your great idea or your innovation there is really tied up in a physical product, which will be available to the public and they can reverse engineer it. So, the way you proceed, it might partly be dictated by form. Trade secrets are pretty inexpensive, to keep it a secret, identify it, put it to paper. And I'll underline Karima's point about the importance of ownership and clarify who owns it, because that is super key. And then you sort of have what it is, and perhaps you can commercialize that and keep it a secret. But that's not always the case, and so certainly you might need to then file a patent application. And again, not everything is patentable. You might be better off keeping something as a secret if you can commercialize it that way, and that's an important discussion to have.
Right.
And I think this from a software perspective, from my lens. A patent is really you can't just publish you can't just patent an algorithm. You have to patent a system, and that system is something that you are making public. And what you are making public, that means people can copy, and then you have to be willing to litigate that patent if somebody is copying you, or you're using it as a protective measure if you're not putting it out there in order to litigate if anybody copies you. And that's probably going to be the case just as a protective measure as a small company, because you won't have the money to litigate. Whereas when it comes to internal systems, for example, how you integrate a machine learning algorithm within a system versus how you made that machine learning algorithm work faster. That piece on how you made it work faster, you might want to keep as a trade secret. Or how you made it more accurate, you might want to keep as a trade secret for a couple of reasons. One, you'd have no way of knowing if somebody is copying your system. Two, in a lot of patents in Europe, for example, you need to detail the system well enough so that somebody could recreate your invention. So you're making it really, really public. And three, the technology moves so quickly that what you've built might not be worth a patent in 1 or 2 years even. So if you think about it with those lenses, a system itself, you could replace the pieces as long as the system is intact. For example, sharing information in a particular way with a third party, as long as that system is still intact, you could replace the pieces but still have a patent protecting that particular system.
Well, that's really interesting. Karima?
Yeah, no, I think we've captured most of it. I mean, the only other thing I would add is sort of look at the landscape, right? Look at the industry within which you're operating, because sometimes if it's a patent intense industry, the patent you're going to get is going to be so narrow that you have to wonder whether it's actually worth it. Or alternatively, if it's a very patent intense landscape, you might want to think about having something just so that you have something that you can use defensively when somebody asserts their patents against you. So it's sort of looking at the industry landscape as well to see whether or not you should be taking on that strategy. But I think Patricia and Lawrence's point, you really, like, a patent is a great tool, but you really have to have what I call the intestinal fortitude and the economic resources to actually be able to enforce it. And so you do have to think about it very, very carefully in terms of whether or not you can do all of that. But to Lawrence's point, if you're operating with something that is easily reverse engineered, you got to think about that very seriously.
And I'll just add too, I mean, there's a bunch of good reasons to get a patent. Some of them are more for marketing purposes than otherwise, right? I mean, litigation, if you get to a point where litigation is a real issue, to a certain extent, you've won, right? So there's money involved and people are interested. So that can be a success. But for really small startups, having at least part of their technology in a patent application, allows some public discourse about what it is, because it's public. That's the deal. You provide an enabling disclosure to the public and you get some protection in return. But you may choose to keep other parts of your system a secret. And having both and being careful with both ends of that continuum are really important.
All right. Well, it's really fascinating, and I enjoyed hearing a lot of the practical thinking and strategy involved in sort of behind the letter of the law, as it were. And so for the next question, I was hoping to get our hands a little bit into the practicalities about, if you were thinking about or actually starting up an enterprise, what you would actually do, what systems would you start thinking about putting in place. And so when you are getting into a data-driven kind of entrepreneurial sphere, what types of systems and safeguards would you think about putting in place, both in terms of protecting secret or confidential information, limiting disclosure, as well as, just to pivot back to the title here, to comply with privacy regulatory regimes if your form of secret does involve personal information? Anybody like to start, or?
That's a big question. But certainly, I think as you get going, it can be overwhelming in terms of all these things you're trying to undergo. There is a sort of an added requirement if you're dealing with personal health information to proceed really carefully, because certainly there is, pretty strict legislation in place that you really should comply with, and that's very important. If you're outside of that kind of personal health space, you still need good data governance structures in place, and those are important to think about. My advice is, an ounce of prevention is certainly worth a pound of cure. And so think about this stuff at the outset, despite having to think about all kinds of other aspects as you're kind of starting a business. But also keep it relatively simple. Better to have a system in place that you can actually adhere to and stick with in terms of data governance, rather than getting all this complex stuff in place and different things in place for all your different types of data. And you could just spend all your time being a data steward rather than actually getting something done and launching a company. So, there's that fine balance between the two, but there's this added rigor that's required if you're dealing with personal health information.
And I'd add that one, make sure your cybersecurity is up to par. That is the number one thing you could do to protect yourself. Number two, to prevent headaches at that point and moving forward, vastly limit the amount of personally identifiable information that you're collecting. Otherwise, there will be really large systems that you have to put in place across your organization as you grow, or as an afterthought a lot of the time, that can be a real pain and cause a lot of debt, technical debt, that is.
Okay.
And I think I would just add, having some processes in place, because in terms of what your employees understand about what their role in all of this is, because I think that is one of the biggest vulnerabilities that organizations have, is their employees and how information is treated, right? Either in terms of disclosure or use, or in terms of, accessing that information or gathering that information. So I think that is one of the things I would think about upfront.
Yeah, training and redundancy. Make sure these two people have the GitHub login, right? Even simple things like that are quite important to think about.
And there's
Okay.
lots of very practical measures that you can put in place, I think, which we can talk about as time permits. But I think at the end of the day, that sort of the lens of approaching the problem is important when you're so overwhelmed with all of the other things that you have to do as you're starting a new endeavor.
Yeah. So what I'm hearing is that it's important and you should have some sensible safeguards. On the other hand, this is a topic where you could burn through an open-ended amount of energy and resources. And I take it your point seems to be, Lawrence, is that you need to also make a viable business model as sort of your first step as an entrepreneur. So you should be mindful of these things, yet at the same time, I don't think you could carry it out in the same way as like a well-established business with revenue streams, etc. You also need to find that path to viability, I think. Is that a fair comment, or?
Yeah, no, I agree. It is overwhelming. It can be overwhelming for the lawyers involved, certainly in the privacy space as well. But there are lots of resources out there. So, I mean, talk to people who have sort of maybe been through it a little bit. The university has lots of great resources. IPON, I'll defer to Karima for that. But don't reinvent the wheel where there are, systems and things out there that you could possibly draw upon. I mean, at Deep Genomics, we develop a lot of these tools internally. We have a lot of people who we pay to code, and that's great. But there are also sort of more off-the-shelf solutions that might be available in terms of data governance, cybersecurity, all these things, and draw on those.
All right. Well, if that's closes off that topic, I was actually hoping to pick Patricia's brain for a little bit about some of the technical privacy side of things. And Patricia, I understand that private AI provides services relating to anonymizing or de-identifying personal information. Can you explain why personal information matters in the context of structured versus unstructured data sets and release models and de-identification? Like, that's quite different from technical secrets, which is what people tend to think of when they think of trade secrets, like how do you make blank or what makes the AI run. But another type of controllable confidential information, at least, is these giant data sets that we're now being able to deal with in some way through AI. So I was hoping you could just walk us through some of the basic terms and tell us what's up and down and that sort of thing.
For sure. All right. So to begin with, personally identifiable information can be chopped into two groups: direct identifiers and indirect identifiers. Direct identifiers uniquely or almost uniquely identify an individual, like names, exact address, things like social security number. And indirect identifiers are things that can, when joined together, increase the risk of re-identifying an individual, like religion, approximate location, disease, things like that. So you have to be mindful about what kind of risk you're incurring as you collect more information about a person, even if you don't have these direct identifiers from them. And the reason this is important is because whenever you're collecting personal data from an individual, you're likely have to fall under the data protection regulation of the area that you're in, or sometimes in the case of the EU, for example, of the data protection regulation where the citizen is from. So the GDPR, which is the General Data Protection Regulation in Europe, completely revolutionized how companies have to think about collecting data. And there are a lot of things to think about when you're collecting personally identifiable information, including, did you get positive consent for all of the uses that you're going to use the data for? Are you keeping track of where the locations are of that data? Are you able to answer access to information requests if a user wants access to what information you have of them? Are you able to answer requests to be forgotten from that information? And a lot more. So basically an entire new technology was created as a result of the GDPR to help people comply with this regulation. And it's not an easy task. So it's something that you have to think about from the very beginning and limit the amount of personal information you collect as a result to prevent the headache. And that's where that's one of the ways that we help, by helping companies remove that PII from structured data and unstructured data. But structured data, usually it's like databases. You have an idea of what the fields are. So you could just, for example, drop the columns with the personal information. When it comes to unstructured data, it's a lot messier. For example, it could be call transcripts, it could be scans of documents and checks, it could be audio recordings, and that you need AI in order to process, and you can bleep out that personal information in the audio, modify the voice to remove the biometric. There's a lot of that needs to be done when it comes to unstructured data and de-identification.
Yeah, there's actually quite a lot to unpack there, some of which is beyond what we can do in one seminar, but just to provide a little bit of background, the European Union's General Data Protection Regulation, there's underlying tension where, you know, as we're sitting here in Canada and talking about it, so there's sort of like international issues around privacy regulation where basically the EU says if you want to have European Union citizens use it, and that's the default unless you've gated your product and nobody on the internet wants to do that, then guess what? You have to follow our rules. And so there's a patchwork of political and legal issues there, which we're certainly not going to get into. But I find it very interesting that it essentially launched an industry, at least partly in Canada, to deal with European Union privacy regulations. So it's sort of a big picture food for thought.
Yeah, just going to add that worldwide, countries are moving more and more towards regulations that are like the GDPR because they need to maintain adequacy with the GDPR in order to get data transferred to them from the EU. So that it's not just for the EU that you want to comply with data protection regulations like the GDPR.
No, there's a bit of a regulatory arms race, but again, I think that's that would be its own topic. But it is in the background here in terms of a lot of what private AI is doing. So I gotta step away from the precipice of that fascinating topic and move on to the next one, if you don't mind, Patricia. And I think I've asked my next planned question a little bit already about what does it look like in practice, and I think the answer is go access one of the resources from IPON or around the university rather than getting into it in this seminar format. So I'd like to say, what are some of the technical and legal considerations you should keep in mind when sharing data with third parties? And should you be sharing data with third parties, and how should you be thinking about that? I think I may have skipped over a step there about one of the most important elements to it.
You know, I think one of the things you should start with is consider what data it is that you're actually sharing, right? What is it? What is the information that's being shared, and why are you sharing it? What purpose is it being shared for? And do you have the consents to be able to share that information? And I think that's the starting point for any analysis, right? I think that's, you know, and then what are you allowing people to do with that data? Like what license is being given to them? What rights are they going to get with respect to anything that they develop from that product? So, I mean, I think those are sort of the fundamental questions that I would start with. And then there's a whole list of other ones that you'd want to tackle, but those would be the fundamental ones. I'm sure Patricia lives this on a daily basis, as does Lawrence in their business. But I mean, I think at a high level, that's where I would start.
Yeah, the can I share this is a good place to start.
Yeah.
And that involves a lot of digging behind the scenes. And then, you know, in what format should I share it? And then what do I get back? I know in our case, often we might be willing to share certain data sets, but then we'll want some, you know, biological data sort of in return, because that we can use to improve our own models and to kind of clarify the IP ownership around any improvements that might stem from the use of the data by a third party. That's an important piece of the puzzle for us. But yeah, there's a lot to unpack there, and drives legal teams to work long hours to sort of do this. But certainly, you know, be very careful when there has to be a good business objective in order to drive that work. So don't just share things kind of for fun, I guess, out of curiosity, because it can have a lot of implications and ramifications.
Yeah. So you should be mindful of it, and referencing back what we talked about earlier, you should make sure that people who work for your organization are also mindful of it, or certainly have been told and ideally signed little slips of paper saying that they will be mindful of it. And so to rephrase it, I think the first order of question is you should almost default to not sharing something unless you've intentionally decided to share it. Like the default should be to preserve your secrecy and confidentiality unless the organization has reached a decision to actually release something. Because for context, like once something's like put out into the public sphere, you lose your legal ability to control it, at least. So
yeah, And I think even within parties, you sort of have to do that due diligence with whom you're sharing the information, right? Because if you're sharing with somebody who, you could write the best contract in the world, but if you're sharing your information with somebody who's unscrupulous, you're really going to create some reputational and legal harm for yourself, right? So I think it's, and taking into account that when you are sharing it, even in a commercial context, the person who you're sharing it with is going to have different expectations, because they're going to want all sorts of warranties around that information and all these rights. And you're going to want to make sure that you are protected in terms of your liability. So, I mean, put that lens on when you're thinking about sharing information, even outside of the public context, but with one particular organization, what that arrangement looks like, because you want to make sure that you're thinking about liabilities, warranties, technical accuracy of the information, how you're going to share it, how you're going to make sure it's secure as you share it, what you're going to do in the way of updates for that information, all of the stuff that I know probably the two of you live on a day-to-day basis. And as a lawyer, that I get the benefit of having that very academic lens on how that works. But in practice, I think it has a whole bunch of other layers that need to be unpacked as you approach the issue.
Kariba, is a follow-up question. You mentioned that RIM had the nickname of litigation in motion while you were there. So could you maybe tell the audience a little bit about what trying to enforce a trade secret misappropriation claim or non-disclosure agreement claim might look like in practice? Like, you have the legal right, and now somebody's using it in the way that you don't
incredibly
think that you
challenging,
should.
right?
Yeah.
It's proving all the elements of somebody unlawfully taking something that you took the appropriate safeguards to protect in order for it to qualify as a trade secret. So you may have had a confidentiality agreement, and then you're saying, well, it's a trade secret. I treat it as confidential. I'm going to enforce it. And you still have to prove that you took all the safeguards. And so, it can think of one particular case where somebody said, oh, but it was disclosed without an NDA, or was disclosed without these markings. It's really a very, very challenging thing to try and enforce it. In my case, I always got the benefit, and I'm using benefit in a sarcastic way, of having to enforce things in the US with a jury trial as a foreign party. And so you can have the best agreements in the world, you can have the best practices in the world, and it's still very difficult to enforce anything. So think really long and hard before you share anything that's sensitive, even when you have an NDA, without having done due diligence on the party with whom you're sharing the information.
I'll jump in and add to that. I mean, a lot of trade secret issues involve, employees who leave. So as much as you might not want to, be nice. and I think that niceness can go a long way. And if, HR departments are sometimes, not vilified, but they have an important role to play. And there's sort of processes in place when someone might leave or when they resign. And sometimes monitoring of downloads and things is a good idea. I mean, there's a famous case of Waymo and Uber in the United States, where a departed employee downloaded a huge amount of information, which ended up in the competitors' sort of files, and they were mistaking the emails back to the originator. Anyways, it was a remarkable case and had some significant damages in the millions, hundreds of millions of dollars associated with it. But yeah, people tend to have a chip on their shoulder, and that's where danger lurks, irrespective of how fabulous your legal contracts and your employment agreements and how that can all be watertight. But nothing is more dangerous than a disgruntled employee who leaves and has access to important information. So.
And I think that raises another point, right? Which is this very practical element of, do all of your employees need to have access to all of that information, right? You have to think about who needs access to what, even within an organizational context, right? So limit those disclosures, put those protective safeguards in, those mechanisms that require you to log in each time and maybe get different levels of access to that information, because it's very easy. And another very practical strategy, apart from being nice, is also reinforcing what those obligations look like as you leave in the nicest of possible ways. But, having employees acknowledge that their obligations continue beyond their tenure.
That's actually quite a distinctive part of confidentiality and trade secrets, is that most obligations employment, like once you're left or you've been terminated, they end. One of the big exceptions to that is preserving confidentiality and trade secrets. So it's something that actually carries on with an individual even after they've left an organization, and that's pretty distinctive legally, actually. I was also going to jump in as a commercial litigator and mention that a lot of commercial activity happens in what I call like the shadow of the law, where there's an understanding of what the legal obligations are, and because you don't want to get involved in a legal dispute, and also just out of a sense of honor and commercial decency, that things tend to be followed. But I should mention that most lawsuits are a time-intensive process, and they are difficult to go through. And in that sense, trade secrets and confidentiality isn't necessarily that distinctive compared to other efforts of needing to sue somebody to actually follow through on an obligation. A little bit, try to see that we may want to turn to some of the questions that are being asked by our audience. I'm trying to get a sense of that. Oh, okay. All right, actually, let's do another a question, but I think we'll have to turn to fielding some questions for the audience in 5 or 10 minutes or so. But I think we have another question or two. Actually, just generally, I'm curious, what particular issues or trends are hot right now in the AI or biomedical fields? I mean, you're involved in those every day, but like right now in 2022 or 2023, what are you encountering when you're trying to get from A to B?
On the AI front, people are talking more and more about the upcoming AI legislation that Europe is going to have in place, and Canada has actually proposed an AI legislation of our own, and it separates different AI use cases from non-acceptable, such as public surveillance from government or security, to high risk. For example, deciding whether or not somebody should get insurance using AI, to low risk, in which case the legislation, at least in the draft that I looked at, doesn't apply. And an example there was chatbots, but that was a contentious issue that might move to higher risk.
Yeah, from my perspective, I think we very much see AI as a tool. It's a wonderful tool, and it's an important tool, and it's a tool we invest a lot in. But in terms of drug development and getting something through and getting FDA approval, we think a lot about mechanism and explainability. We can't just have this kind of black box that takes us from A to B. And so that's something that we still think about. And there are certainly ways now of sort of explaining how you got from A to B using an AI system. But those are still, I think, of interest to biologists, and not simply plugging information in and getting an answer. That's great, but you need some kind of explainability or confirm the mechanistic aspects of the answer you've gotten. And as we see more and more of these tools come out, like for protein folding or for predictions, that's important, and even for diagnostics as well, which is not an area that I'm as active in currently. But I think that's still an area of interest from the biology standpoint.
I think outside of the regulatory regime at a transactional level, I think there's a lot of consideration around having ethics committees to actually govern what that end product, how it's going to come to market, what the implications are going to be, and also around ownership, around IP that is generated as a result of the use of somebody's data. Who's going to own, the algorithm? Who's going to own the output data? What rights are the licensor going to have? What rights is the licensee going to have? I think some of those allocations are becoming increasingly more pronounced as people start to recognize the value of the data, right? And the value of the IP that comes out of it. So, from a transactional perspective, those are some of the things that I'm seeing. I'm not within an organization, and so don't have the benefit of being able to look at what's really happening with feet on the ground. But in terms of looking at transactions, that's certainly what I'm seeing.
All right, well, that's very interesting. There's actually one more question I wanted to touch on, just to distinguish between different terms and concepts that are floating out around there, if you read about it. And I was wondering, I know Prima had talked about some of the grim realities of actually needing to enforce legal rights, especially if you're smacking into the American jury system. And I know you mentioned, Lawrence, that this is often an employment dispute. And for me, like that strikes me as something as you have an established individual in Canada or sort of a rule of law country do something. And so you can usually start a lawsuit. And that tends to be the background where you can actually try to enforce a trade secret misappropriation or an NDA breach as a background. Now, having said that, is anyone willing to differentiate the concept of a cybersecurity or data breach incident and how those are a little bit different? Like, I'm not expecting to get into a lot of detail here, and I know I could field my answer, but like we've been talking about what you can do against individuals and companies that you've identified in a jurisdiction with a somewhat fair court system. And if you're dealing with a data breach, what are you dealing with there? How is that different? Perhaps I should answer the question myself, although
Well,
You'd probably be
very
a great
different.
starting point because you probably litigated a few.
well, one of the points I would make is that if an unknown hacker is sitting somewhere in either the former Soviet bloc do something, it's like that's terrible, but through what court system do you expect me to run a system that's John Doe A, John Doe B, John Doe C, etc. Whereas I know that's a really big issue in the research space, but one of the things we're talking about is to launch an actual, to enforce your legal rights, they need to be able to start a lawsuit through a court system against people you could identify. And so a lot of the cybersecurity incidences are really about risk management in the front end, or frankly, trying to avoid getting tagged with negligence liability if you're the institution and you just have a data breach. So that's not quite the same thing as having a disgruntled employee leave who you know who they are, you know where they've arrived at, and you can maybe do something about that. Whereas, although a lot of the data sets involved around cybersecurity are similar, I just wanted to briefly flag that you can't really,
They're very different, right?
Yeah.
I mean, for one, you don't have a person you can sue, as you said. Who is the adverse party there? They can be extremely adverse, and But so I think it goes to, again, having good processes in place, especially for cybersecurity. And again, I'm not sure of the availability of insurance for some of these cybersecurity attacks now. I think in some cases, it's hard to get cybersecurity insurance anymore, or it's very, very expensive.
they took it away.
That is something you should, yeah.
They took it
be very-
because they used to give payouts for insurance, and then they figured out that as soon as it was insured, then everybody would roll over as soon as it got.
Yeah, it's
So
hard.
you
Yeah,
can't-
so you need to be, aware of that, and therefore the ounce of prevention is all you've got. So.
All right, so I just wanted to mention that because they are very different topics from, I think, our perspectives, but they often swirl around in the news media in the same way. So I just did want to touch on that. I think we've had a number of questions popping up, so I was going to pivot to talk about some of those. First up is